the reality is that most people really do understand these rules. And by the way, people are actually signing up, registering their automatic assault weapons, their high capacity magazines rather, and as we get closer to it, we're seeing more and more people actually do what they're required to do under the law.
One thing we see across the board is that the people who are banning them rarely understand the basic mechanics of the guns and the magazines that they're banning. The more they talk about it, the more they betray a very woeful ignorance about the Second Amendment and about the actual arms that are in question. We see that on both the state level and the federal level. You can get a few real laughs sometimes listening to what congressmen say in some of these gun control hearings that they have from time to time on the Hill.
That's Hannah Hill right after Governor J.B. Pritzker talking about registering fully automatic firearms and high-speed, high-capacity magazines. Welcome back. It is Bishop on Air, and this Monday morning after last week, some things happening with the courts, especially the U.S. Supreme Court denying the Naperville plaintiffs' motion to intervene, to have an emergency injunction put into place. So we've got a couple of different things that have happened there, and I wanted to share with you a conversation I had with Hannah Hill from the National Association for Gun Rights, and she provided some reaction on Friday when I chatted with her about what this means moving forward.
So honestly, the news that we got yesterday in terms of the underlying case against the Illinois assault weapons ban is not as discouraging as it felt like to all of us, although I mean, it unfortunately does not block the law for the citizens of Illinois. That's the heartbreaking part of it. And that's what the emergency appeal was about. It was about trying to stop this law from imposing any further tyranny on the law-abiding citizens of Illinois. It's very, very unfortunate that the Supreme Court did not listen when we said that a right delayed is a right denied. But that decision's been taken out of our hands. Applying for emergency relief is always a Hail Mary. We've done that twice on this case, as the Second Circuit first dragged their feet about saying, this is an unconstitutional law, and then came right out and ruled that AR-15s are not actually guns for purposes of the Second Amendment. So we were hopeful when the Seventh Circuit said, no, we're not going to rehear that case, that the Supreme Court would be a little bit more interested in stepping in. And frankly, that actually may be the case. That is what we are hoping. Because from the Supreme Court's perspective, they would rather step in on the actual case itself. Whereas if they had granted the emergency relief, it would have done nothing to overturn that outrageous Seventh Circuit ruling, right? It would have been an emergency stay. That's all it would have been for that law. We might not even have gotten a ruling. It could have been just a one-sentence order. And while that would have provided relief, very, very important relief for the citizens of Illinois, it would not have done anything on the main actual case. Besides, we all knew the reality is that the Supreme Court rarely gives that kind of emergency relief. We've only seen it a handful of times. And certainly they've not done it on Second Amendment cases. Every time somebody has asked them to do it, almost every time someone's asked them to do it on a gun case since Bruin, they've said no, and they've indicated over and over again that what we want to do is wait until you bring us the actual case, the lower court process is finished, and then we'll weigh in. So the good news is we know the court's interested, because twice now, Amy Coney Barrett has asked for a briefing from Illinois. When we've asked her for emergency relief, instead of saying no, she turns to Illinois and to the city of Naperville, who's also a defendant on our case, and goes, all right, so tell me why I shouldn't do this. Tell me why I shouldn't block your laws. And so they did, and they gave some pretty nonsensical arguments. Then she referred that to the entire court both times, and it was a joint decision from the entire court. But the thing that happened this time was the Seventh Circuit said, no, we're not going to rehear the case en banc. We are not going to reconsider that panel ruling that said that AR-15s aren't guns for the purposes of the Second Amendment. That ruling makes a mockery of both Heller and Bruin, two Supreme Court precedents that they just outright defied. I am very hard pressed to think that the justices are going to take that sitting down. And that may be actually why they said no, because they know that we are going to be bringing it back on cert, asking them to overrule that very ruling. We know they're interested. We know they're watching. And we're very hopeful that when we do bring it back and file for our cert petition, which is due the second week of March, that that we'll get a different answer from them. Because again, they have to decide if they really meant what they said in Bruin, and frankly, what they really said in Heller. After Heller, they saw lower courts trample it time after time after time. Routinely, they pretend that Heller didn't happen. And the whole point of Bruin was to say, oh no, we actually really meant it. You know how they reestablished that text, history, and tradition standard in Bruin? That wasn't a new standard. It was first laid out in Heller. And anybody who reads Bruin comes away with a very clear distinction that the court was trying to say, we meant what we said when we gave you Heller, and we actually do mean for you to follow that in your rulings. But if they don't want a repeat of what happened 10 years ago with Heller, it's going to take taking some cases like ours before the lower courts get the idea that, oh, no, we actually do have to apply what the Supreme Court said this time. We actually do have to follow Bruin. So it's going to be really up to the court just how much of this lower court defiance they're willing to put up with.
So again, sharing some of the conversation I had with Hannah Hill from the National Association for Gun Rights on Friday, and really about what the next steps are, right? Because you've got the request for an emergency injunction that the U.S. Supreme Court essentially denied after Justice Amy Coney Barrett took the pleadings and the response from the state and put it to the whole court, and then the whole court on Thursday denied that emergency injunction. But Hill also talked about what the next steps are, and in particular where we go from here with after the Seventh Circuit U.S. Court of Appeals denied an en banc review. What does this mean for the next deadline for the plaintiffs in this case to actually file a full writ of certs?
A lot of cases do get decided on the preliminary injunction, right? A lot of cases never actually make it to the going to discovery and going to trial and then summary judgment. Some of them do. We have two cases against assault weapons bans and magazine bans in Colorado that are going through that process now. But most cases, initially, you see the fireworks over the preliminary injunction side. And we've asked for that at the district court and got denied. The Seventh Circuit ruling I was just talking about was over the preliminary injunction. And, lawyers may argue about what on the merits means, but the Supreme Court does take preliminary injunction cases. That's not considered emergency. That wouldn't be shadow docket. That would be an official appeal of the case. And it would be we would be asking them to overturn the Seventh Circuit's panel decision. So it's in a different category, a category that the court is willing to consider, unlike what we just filed, which was the appeal for an emergency stay, which goes on the shadow docket. They can step in and give relief if they want to do that. So our cert appeal is due 90 days from the denial of en banc review at the Seventh Circuit. 90 days, that's going to put us about in the that's going to put us about in the second week of March. And obviously our lawyer is going to take the time to get it right, but we are anxious to file it as soon as possible. So definitely stay tuned for
So Hill talking about the next steps here and how 90 days from when the Seventh Circuit denied en banc, they can actually take the case back to the U.S. Supreme Court. So that's something to consider as we move forward. Of course, that still leaves that January 1st deadline in place, and that's something that has a lot of people seriously concerned because look at the calendar. Today is the 18th. Is that what today is? Yeah. So you've got next Monday is Christmas. And then the next Monday is January 1st. So that's the deadline to register firearms that the state has banned. Or if you get caught with those without registering, you could face a felony charge on the second offense. So here's Hannah talking about the January 1st deadline and how it seems that, at least from their case perspective, that's going to be in place.
It breaks my heart that they are facing it. That was why we asked for the Hail Mary move of an emergency appeal. We were hoping the Supreme Court would step in and take away that quandary. I will give the advice I always give. That is, seek your own legal counsel and on that question and make the decision that seems best to you. But definitely consult your own lawyer on that. And we can definitely help connect you with solid Second Amendment attorneys if anyone's interested and needs a recommendation on that. This is why our organization exists, is to keep these choices from being put before the people. But unfortunately, when state legislators are elected that routinely and deliberately trample on the people's rights, the court remedies are very slow and they're very uncertain, as we have seen. And I would encourage people to remember this at the ballot box, and to mobilize and to get involved in holding the lawmakers who put this on them accountable for their decisions, regardless of what party they are. Vote gun rights when you go to the ballot box.
And again, this is Hannah Hill, the National Association for Gun Rights Executive Director, who's representing the Bevis plaintiffs out of Naperville that took their case to the U.S. Supreme Court. But last week, we heard Governor J.B. Pritzker talk about the lack of registry rules being finalized and how there's a lot of confusion out there. And he had this to say to that, and it's got a lot of people's attention as to whether the governor fully understands the law that he signed. Here's Governor J.B. Pritzker last week, and got Hannah's response to just some of the lack of understanding of definitions of sorts.
The reality is that most people really do understand these rules. And by the way, people are actually signing up, registering their automatic assault weapons, their high capacity magazines rather, and you know, as we get closer to it, we're seeing more and more people actually do what they're required to do under the law.
So Hannah said that it just seems to be more of the same of lawmakers wanting to ban certain types of firearms, not necessarily understanding what the firearms they're looking to ban are.
So we know the whole thing is political, right? Assault weapon isn't actually a thing, right? They're basically they call it assault weapon because it's a scary term, and they're trying to win the battle for public opinion in the minds of the judges and everybody else. But an assault weapon is not an industry term. It's just a term for a gun that looks scary. So, and that's one of the things that we make in every single one of our lawsuits. Yeah, we sometimes have to use their shorthand, but we always do so with the footnote that, hey, we know, we need the court to know that the assault weapon is a politically charged term deliberately crafted to make these guns look bad unfairly. So that's the first thing. The second thing is that one thing we see across the board is that the people who are banning them rarely understand the basic mechanics of the guns and the magazines that they're banning. The more they talk about it, the more they betray a very woeful ignorance about the Second Amendment and about the actual arms that are in question. We see that on both the state level and the federal level. You can get a few real laughs sometimes listening to what congressmen say in some of these gun control hearings that they have from time to time on the Hill. And the final thing is, we see this is kind of the go-to. This is kind of the gold standard for blue states. When they want to trample the Second Amendment, what they really want is a ban on AR and AK style firearms, right? That's America's rifle. It's most Americans' number one choice for self-defense tools. And that's why it's so concerning that that's the number one thing that gun grabbers want to take away. And our argument is basically, if it's America's choice, you don't get to second guess that. You don't get to take that away. If it's in common use for lawful purposes, including self-defense, you can't take that away. And that's exactly what Heller said, and that's exactly what we're arguing in all of these cases. But at the same time, that is the gold standard for gun control. That's what Joe Biden has said over and over again that he wants. Every move that you see from the ATF, chipping away at the right to self-defense with, we're going to ban this accessory and we're going to ban that accessory that Congress, mind you, never banned. What they're going for is they're going for the semi-auto. With every step they take, every time they chip away at that right, what they're trying, the trajectory is to ultimately get an AR-15, AK-47 type rifle ban enacted by hook or crook, with or without Congress. And that's why it's so important to stop the ATF's depredations on our rights. And that's another thing that we're working on in the courts as well. But you see it at the state level also. I live in the state of Colorado, which is very sadly now a very, very blue state. And we just barely stopped a state level assault weapons ban from passing. We got a standard capacity magazine ban passed in 2013. We're fighting that in the courts now. But the legislature came that close to passing an assault weapons ban. We stopped it earlier this year, but it's going to be back, and we're going to have to keep fighting that. And as states turn blue, you're going to see that become more and more of a battle. And that's why it's so important for conservatives and gun rights supporters to keep control of their state legislatures and their local governments, because these pass at the local level as well. That is a very deliberate Lindbergh strategy. That's how our whole program started. It started by challenging 4 local assault weapons ban ordinances here in Colorado that were passed in response to basically a ground assault from these national anti-gun groups like Moms Demand Action and such as that, Every Town for Gun Control, Giffords. They were all agitating in this really liberal area of the state, and they got 4 different local governments to pass assault weapons bans. That's how it started. A lot of times as voters, we overlook the importance of our city council races and our county council races. The left does not do that. And if you want to hang on to your gun rights, we shouldn't do it either.
Again, that's Hannah Hill. She is the executive director for the National Association for Gun Rights, reacting to Thursday's news of the U.S. Supreme Court denying the preliminary injunction while the case plays out, saying that they are going to file directly to the U.S. Supreme Court by mid-March, if not earlier, a challenge. But obviously that does nothing for the January 1st deadline to register certain semi-automatic firearms, as you've got that deadline now 2 weeks away, and a lot of people questioning exactly how they're going to actually handle that situation. It is Bishop on Air. Be sure to like, subscribe, hit that notification bell. We will update you each and every weekday morning here on YouTube, X, and Facebook. Greatly appreciate you guys tuning in.